Hey guys, welcome back to the channel. Today we're diving into a key topic in Singapore's legal landscape that many people have heard of but may not fully understand: mediation. Mediation has become an increasingly popular method for resolving disputes in a cost-effective and efficient manner. So let's explore what you need to know. So what exactly is mediation? Mediation is a voluntary process where a neutral third party, called a mediator, helps disputing parties reach an agreement. Unlike a judge, a mediator doesn't impose a decision. Instead, they facilitate discussions to help parties find common ground. It's a confidential and non-adversarial process, meaning it is much less confrontational compared to litigation, that means suing in the court. Mediation is used for a wide range of disputes, from commercial disagreements to family matters. First, it's usually faster and cheaper than going through a full court trial. Secondly, because mediation is a private process, the details of the dispute remains confidential. Finally, mediation allows the parties to come to a mutually agreeable solution, as opposed to having a decision imposed on them by a judge. Now, let's break down the two main avenues for mediation in Singapore: the mediation process at the state courts and the Singapore Mediation Centre. Mediation at the state courts typically occurs during the pre-trial stage. When a case is filed, the court may direct parties to undergo mediation, especially for disputes that the court believes could be settled amicably. Mediation is strongly encouraged by the courts, and parties who refuse to mediate may face cost consequences later on. For magistrate court lawsuits, parties are required to file an ADR form known as Form 6 before the first hearing. Parties have to choose an ADR option in Form 6 or provide very good reasons for not wanting. Usually that the dispute involves a question of law or a novel legal issue. The judge mediator is a trained judge who acts as a neutral party to help the disputing parties reach a settlement. Keep in mind that this judge does not decide the case or give a judgment, but instead facilitates the discussion. So what can you expect during a state court's mediation session? The process usually begins with a joint session where both parties present their positions. Then, the judge mediator will hold separate sessions with each party, which are confidential. This is to allow the parties to discuss their concerns openly with the judge. After hearing both sides, the judge mediator will help identify possible solutions. But ultimately, it is up to the parties to agree on the terms. The mediator may highlight the weaknesses of the claimant's case to try to get him to lower his amount to, say, 60,000. And the mediator will do the same to the defendant and ask him to give a higher amount, for example, 80,000. It is essentially like bargaining over the price of vegetables at the market. Most of the time, parties will be able to arrive at the number that one is willing to pay and the other willing to accept. Now, it is important to note that not all mediation outcomes are purely about money. While financial settlements are common, mediation allows for a variety of flexible resolutions that might be more meaningful to the parties involved. Let's take a look at some of these alternative outcomes. One possible outcome of mediation is an apology. In many cases, what the aggrieved party really wants is a simple acknowledgement of wrongdoing. An apology can often diffuse tension and rebuild relationships, which may be especially important in business or personal disputes. Another possible outcome is an undertaking not to repeat a certain act. For example, in a commercial dispute, one party might agree not to engage in certain competitive practices or to stop using a trademark that is under dispute. This can help protect the claimant's future interests and prevent the conflict from recurring. In cases involving defamation or other reputational disputes, mediation could lead to the withdrawal of a publication or an agreement to issue a corrective statement. This allows parties to restore their public image without the drawn-out process of going to trial. These outcomes highlight one of the key benefits of mediation: its flexibility. Unlike court judgments, which are often restricted to monetary damages, mediation allows parties to tailor solutions that address their unique needs and interests. This not only helps resolve the current dispute, but also fosters better long-term relationships between the parties. The biggest advantage of state court mediation is that it's cost-effective, as it's typically included as part of the court process. Also, the mediator's judicial experience is often helpful in guiding the parties to a practical and legally sound solution. However, if mediation fails, the case will proceed to trial, so it's important to enter mediation with a mindset focused on resolution. While state court mediation is typically part of an ongoing legal process, The SMC offers a mediation outside of the court system. This means that parties can choose to mediate before even commencing a lawsuit, making it an ideal option for those who want to avoid litigation altogether. To start mediation at the Singapore Mediation Centre, one or both parties can submit a request to mediate. Once both parties agree to the process, the SMC will appoint a professional mediator. The mediators at SMC are typically experienced professionals from different industries, including lawyers, accountants, even engineers, depending on the nature of the dispute. At SMC, mediation usually starts with a preliminary meeting to establish the ground rules. Then, much like in the state courts, the mediator will conduct joint sessions and separate sessions to understand each party's concerns. SMC mediators aim to foster a collaborative atmosphere, helping parties explore creative solutions that might not be available in court. One unique feature of the SMC is that it offers various types of mediation services, including specialized mediation for construction, intellectual property, and community disputes. The SMC also has a very high success rate, with about 70% of cases reaching settlement within a day. Unlike state court mediation, which is often free or low cost, however, these fees are typically lower than the cost of going to court, and many parties find the process to be worth the investment, given the time and stress saved. To conclude, whether you're in the state courts or at the Singapore Mediation Centre, mediation offers a less stressful, more collaborative way to resolve disputes. It's faster, more flexible, and often less costly than going to trial. And with the guidance of trained mediators, parties often reach a solution that both sides can live with, rather than having a decision imposed on them. Thanks for watching. Don't forget to like, share, and subscribe. Until next time, stay informed and stay empowered.